deep dive into a Supreme Court case that, I mean, it really turns everything you think you know about inheritance on its head.
Absolutely. We're looking at Radhamma Ors VHN Muddukrishna.
And we're going to use it to answer a pretty terrifying question. Can a secret piece of paper just steal your birthright?
It's a case that really pits ancient family expectations against modern law. You have a family that believes they have a guaranteed share of ancestral property.
Yeah.
And then they find out the patriarch, well, he had other plans.
Right. So the story revolves around a man named Patel Hanumegoda. He had this land, some he bought, some was ancestral. And then in 1976, a part of his family sues. They're claiming their 1/10 share.
And their argument is that they're coparceners. That's the key term.
Let's break that down for a second. What exactly does coparcener mean here?
It's legal speak, really, but it basically means you're born into a joint family and you have an automatic birth-given right to a piece of the family property.
So the moment you're born, a piece of that land is yours.
That's exactly what they believed. But they hit a brick wall.
The will.
The will. It turns out Patel Hanumegoda had executed a registered will way back on June 16, 1962. He then passed away in 1965.
And those dates are so important here. The will is from 62, he dies in 65, but the lawsuit doesn't even happen until 1976.
That's more than a decade.
It's a long time for a family secret to just sit there, while everyone assumes things are one way.
And that timeline isn't just for drama, it's the entire legal key to this case. To understand why the family lost, you have to look at the law before and after one specific year.
1956.
1956.
So what was the rule before that?
Before 1956, you had the old Mitakshara law, and the main rule was survivorship.
I think of it like a big family pot of money. If one person died, their share didn't go to their kids through a will.
No, it just dissolved back into the pot for everyone else who was still alive. You just couldn't will away your undivided share. It was locked in the family.
But then came the Hindu Succession Act of 1956, the great disruptor.
It really was. And specifically, Section 30 of that act changed everything. It introduced what's called Testamentary Succession for these exact situations.
Which is just a fancy way of saying
The power to decide who gets your stuff after you die.
by writing a will.
Exactly. Section 30 made it explicit. It said a Hindu male could now dispose of his interest in this kind of joint family property by will. It basically told the old survivorship rule to take a back seat.
And since Patel Hanumegoda died in 1965, that's 9 years after the act was passed.
He was playing by the new rules. The Supreme Court looked at the dates and said, well, Section 30 gave him the absolute right to give away his share.
So the will was valid.
The will was valid, the share was transferred, and it never went back into the family pool.
Which means the family members who sued
Had no claim. None at all.
Now, they didn't just give up. They tried to argue the will was, a fake. They pointed to that huge delay as a suspicious circumstance.
And this is where the case pivots a little bit. It moves from property law into evidence law.
Right, because the court wasn't really interested in the vibe of the situation. They wanted cold, hard proof.
They looked at Section 68 of the Evidence Act. And that section is very procedural. It just asks, did you follow the rules to prove the document?
And the other side did. They brought in the witnesses who were actually there, who saw the man sign the will.
And the court said that kind of direct proof, it just trumps vague allegations of suspicion. Unless you can prove actual fraud, which they couldn't, the will stands.
This is such a wake-up call for anyone listening who just assumes their inheritance is a sure thing because it's ancestral property.
It is. That idea of a safety net, it's not as strong as people think. A valid will can completely change the equation. That old right of survivorship is not absolute anymore.
A father can now leave his share to a neighbor, a charity, or just one kid and completely cut out everyone else.
And it's all perfectly legal.
It's just amazing how modern statutory law can just, overwrite centuries of tradition and family expectation.
It rewrote the entire financial reality for this family.
It makes you wonder, doesn't it? How many other guaranteed family rights are actually just one piece of paper away from disappearing?
Something to think about.
Definitely something to chew on. Thanks for joining us on this deep dive.
Until next time.